In this High Court case, Mrs. Coffey was the wife of a police officer and the mother of a little baby. She had had a difficult life prior to meeting Mr. Coffey, but their marriage was a happy one. One day, Constable Coffey had been riding a police motorcycle when he was hit by Mr. Jaensch's car. Mr. Coffey was grievously injured and rushed to hospital. Mrs. Coffey went too. She saw him on the hospital gurney with tubes and wires connected to him. She was aware that after surgery his hip displaced, causing unbearable pain, and she overheard medical staff say that he was not likely to survive. Some days later she suffered severe nervous shock. It was sufficiently severe that she was admitted for inpatient psychiatric care and could not look after her child. She also ultimately had to have a hysterectomy for reasons which her treating doctors linked to her stress and anxiety. Now, the courts have always been very cautious indeed about allowing negligence claims for psychiatric or psychological injuries. It's a slippery slope which might ultimately result in tortfeasors having almost unlimited liability, potentially to thousands of people who might feel themselves affected by an incident, all of whom might argue that the harm to them was reasonably foreseeable. Previously, the law had done this by requiring physical proximity. In other words, you had to be there and see the physical harm to make a claim. In this case, Justice Dean broadened the requirement in two ways. First, he found that there are three types of proximity: physical proximity between the plaintiff and the defendant, circumstantial proximity, such as an overriding relationship of employer and employee, and causal proximity in the sense of the closeness or directness of the relationship between the particular act or cause of action and the injury sustained. He then found that circumstantial proximity might take liability past the immediate location of the cause of action. So even though Mrs. Coffey was not there on the roadside, there was causal proximity between the collision and her seeing her husband in the hospital. The court found for Mrs. Coffey. Since that time, proximity as a test has been doubted and debated in the courts, and of course the Civil Liability Acts have changed everything. This is an important case to know, but be very careful to bring your knowledge up to date.